Hello, everyone. So we are just done with the foundation paper. And yes, this time locker paper was a little easier comparatively and quite a satisfactory paper also. And today we are going to discuss this paper in details as to what should be the answer of the question, what provisions and everything. So starting with the first question, ABC Infrastructure Limited was running business successfully from several years. P was the purchase manager of the company. He authorized his agent Q to buy raw material on his behalf for construction of roads in Delhi. He instructed Q to buy only Majboot brand of cement at 2000 or 2500 per ton to maintain quality of roads in Delhi. However, Q bought 1000 tons of Majboot brand of cement from Mr. R, a very well known vendor of ABC infrastructure, at 3500. Okay. So I have given instruction to my agent to buy at 2000 or 2500 per ton, but this agent goes and buys at 3500 per ton. So he has acted outside authority. Correct or not? My agent has acted outside authority. Mr. Q has not disclosed the fact to R that he was buying cement for the company. That means he has not even disclosed that he is acting as an agent. Not disclosed he is agent. That means he's contracting in his own personal name. When P discovered this aspect, he refused to pay Mr. R and rejects the cement bought by Q on the ground that Q had exceeded his authority. Can P actually do that? Two things here. He has exceeded his authority. So, yes, I can. And plus, this contract is I cannot separate it. 2500 I'll accept. I'll not pay the rest. We cannot do because ratification must be of the whole contract. So, can he reject? Yes. Mr. R suffered a loss on account of this transaction. Whether P was bound to pay Mr. R? No. Why? Because in case of authority given to an agent, if the agent exceeds his authority, the principal is not liable unless he ratifies it. On the other hand, Q, being agent, refused to accept any liability to compensate R. In this situation, whether Mr. R can file a suit against Q. Here, since Q did not even disclose that he is acting as an agent for another person, can we say there is a liability on the part of Q to pay? Or I mean, he's not acted as an agent. So whenever the agent does not act in the name of an agent, but he acts in his personal name, in that case, the agent becomes personally liable. So, can R file a suit against Q? Yes. State with reasons whether the following companies can be treated as small companies. STS Private Limited having a turnover of 10 crores. Okay. To be a small company, just 1 second, guys. So, STC Private Limited having a turnover, so for a small company, the paid up capital should not exceed 4 crores and turnover should not exceed 40 crores. Turnover is 10 crores and paid up capital is 1 crore. So both is within the limit. Out of this, 60,000 shares are held by UV Infratech Private Limited. Now, if you miss out this information, you might miss out on this fact that STCS Private Limited is a what? Subsidiary of UV Infratech Private Limited, correct or not? Right? An interesting question, right? Is a subsidiary of UV Infratech Private Limited. And as per Section 2, Clause 85, if you are a holding or a subsidiary, you don't get the status of a small company. So even though it fulfills, it cannot. ZX Limited has a paid up capital of 3 crores and turnover of 35 crores. Can it be considered as a small company? Yes, because it fulfills both the criterias of small company. The paid up equity share capital of ACD Limited is 80 crores and preference share capital of 20 crores. B Limited holds equity shares worth 15 crores and preference shares worth 10 crores. Could it be considered as an... So for associate company, you need a holding of how much? At least 20% of the significant... You must have a significant influence. And significant influence means at least 20% of the total voting power. What is the equity share capital? 80 crores. Right? We don't take preference shares because preference shares don't give you any voting right. So what is the paid up equity share capital? 80 crores. And out of this, how much is ACD Limited holding? 15 crores. So how much is 15 crores of 80 crores? How much is 15 crores of 80 crores. So what is the holding here? 15%, 15 crores out of 80 crores. It will come somewhere to 18.75%, which is less than 20%. So it cannot be considered as an associate company. In accordance with the provisions of the Indian Partnership Act, explain the following. The rights of an outgoing partner to carry a competing business. Okay. When a retiring partner leaves the firm, he has a right to carry the same business as that of the firm if there is no agreement to the contrary. However, when he carries the business of the firm, he cannot show his connection with the firm. Neither you can use the name of the firm or the connection of the firm, or nor can you solicit the customers of the firm. In this case, he can carry on a similar kind of business. The rights of a partner to be indemnified by the firm and the liability of the partner to indemnify the firm. So, this is basically rights and this is basically duties. So, right to be indemnified. If a partner pays any expense on behalf of the firm, he has a right to be indemnified for the expenses paid. In an emergency, if a partner acts outside his authority to protect the interest of the firm, and while doing the act, he incurs any liability, the firm should reimburse or indemnify him for all that expenses. Liability if due to his fraud or his willful neglect, the firm suffers any loss, he has to compensate the firm for that loss. S purchase the dress. Okay, this was a very new type of a question, but we had done this question, same question in the class. If you remember the books, 50 books you had purchased. S purchase the dress from a reputed showroom. Can I say it is specific goods? Yes. And made the payment in cash. The dress she purchased required some alterations. So they are specific goods not in a deliverable state. Because unless the alterations are done, right? Unless the alterations are done, the goods cannot be taken. The shopkeeper assured us that it would take just one day to get the dress altered. So, if the goods are specific goods not in a deliverable state, when is the ownership transferred? After they are brought to a deliverable state. Second, the buyer is informed. The shopkeeper assured us that it would just take one day to get the dress altered. It was agreed that once the dress was altered, the shopkeeper would inform us through phone and she would collect the dress. Next day by evening, the dress was altered and kept ready. The shopkeeper, however, forgot to inform us that the dress was ready. So, is the ownership of the goods transferred to the buyer? No, because if no time is specified when the transfer of ownership will take place, then if the goods are not in a deliverable state, ownership is transferred after they are brought to a deliverable state and the buyer is informed. In the meantime, a short circuit occurred near the delivery counter of the shop and some packets ready for delivery caught fire. After waiting for 10 days, when NS went to collect her dress, she was informed that she came late and her dress was burnt in fire. S then asked for the refund of the money that she had paid. Shopkeeper refused by saying that the dress was kept ready and the very next day of purchase and the loss due to fire occurred after a week. He refused to bear the liability by saying that if S had collected the dress on time, it would not have been burnt. S insisted that she was waiting for a call from the shop and thus entitled to claim the refund. Examine whether the shopkeeper will be liable to refund. Yes, because the shopkeeper had not informed us about the ready the goods were ready. It is the shopkeeper who's the owner of the goods and not the buyer who's the owner, and so he has to return the money back. Doctrine of indoor management allows all those who deal with the company to assume that the officers of the company have observed the provisions of the articles. In the light of the above statement, explain the so you have to talk about doctrine of indoor management. Make sure you write about Royal British Bank versus Turquin and its exceptions, if any. So here, what are the lochas to this rule? Knowledge of irregularity, no knowledge of MOA or AOA, negligence, or in case of forgery. In all of these cases, you cannot claim any relief. LLP gives the benefit of liability of a company on one hand and the flexibility of partnership on the other. Such a common question. The institute keeps asking this so many times, right? We already know LLP is a combination of partnership and company. It's basically a hybrid, right? So whatever, the points of company and the points that is flexibility of partnership, that they can decide about the terms of the agreement. as they want, whereas it has perpetual succession and it has limited liability. Raju and his friend Anil have approached you to help them to form an LLP. The object of the proposed LLP is to run a charitable school which provides free education to the poor children. What would be your suggestions in accordance of the provisions of the LLP Act? When we talk about LLP Act, generally the motive of LLP is always to earn profit. We don't have any non-profit LLPs. In fact, the LLP Act does not even say, in fact, the LLP Act says the motive of LLP is always to earn profit. So, as per this, they wanted to start an LLP to provide free education. That means it's a non-profit LLP. So they cannot start any non-profit LLP. So what would be your suggestion? They cannot incorporate such an LLP because the objective of LLP is always to earn profit. One of the characteristics of LLP is to earn profit. ABC and Company is a renowned partnership firm doing business in textile industry from the last 20 years. But due to technical upgradation, firm incurred heavy debts of 50 lakh. To maintain the integrity of the firm, they introduced D as a new partner. Before admission of D, other partners A, B, and C decided on their own and made an agreement with the creditor that the new partner will be liable for the existing debts through novation. When D joins, he came to know about the debts with reference whether D would be liable. Now, they have decided through novation, but here novation should happen between A, B, C, D and the third party, correct or not? ABC have agreed with the creditors, but D was not involved, and unless D is involved, he is not liable. So the novation should happen between A, B, existing partners, new partners, and the third party. So would he be liable? No. The new partner is liable only for the acts of the firm done after his joining the firm. Whether your answer will be different if D was minor at the time of admission? No, because when we talk about minor, the liability of a minor is limited only up to his share. He is not personally liable. Third, whether D would be liable to pay the debts upon becoming a major. In case of a minor, minor's liability is from the day he was admitted to the benefits of the firm. As per that, any act which was done while he was a beneficiary makes him liable. However, when D joins the firm, this debt was already existing. So, if this debt was already existing, how can I hold D liable? So, still the answer would be the same. The object clause of Memorandum of Association of ABC Private Limited authorized the company to carry on the business of trading in property in Gurgaon. Since the company was not doing well, the directors of the company in a recent board meeting planned to diversify the business and enter into the construction business. For this purpose, they borrowed a sum of 5 crores from Magnum Finance Limited. But the members of the company did not approve the decision of the board. Hence, company refused to repay the loan. Analyze what is the recourse available to Magnum Finance Limited. Well, first of all, if the contract is ultra wires, ma'am, how would the outsiders know that the contract is ultra wires? Whenever outsider comes to deal with the company, we assume that they have read the articles of the company, they have read the MOA of the company, and they know what are the powers. So, if the debt is ultra wires, first of all, the third party cannot recover this money at all. Now, if the debt is ultra wires and the debt has not been utilized, right? The debt remains unutilized. In that case, Magnum Finance can get an injunction order. Magnum Finance can get an injunction order against this loan. That is, they can get an injunction order against the company that since this loan is ultra wires, you cannot utilize this money. This will happen only if the money remains unutilized. Then they can get an injunction order. So, Magnum Finance Limited cannot sue for the recovery of the loan since it's ultra wires. However, if the loan remains unpaid, they have a right to move to the court to get an injunction order for non-utilization of this money. So, Magnum Finance Limited can sue the company for injunction. SNM Limited was registered in 2021 with a share capital of 50 lakh divided into 5 lakh equity shares of 10 each. Under Section 8 of the Companies Act for promotion of an art in Jaipur, Company earned huge profits and there was a boom and they want to declare, okay, on 75% of the members demanded to distribute 10% dividend. Can they declare? Where it's a Section 8 company, and one of the objects of the company is they cannot. It's not they may not, they cannot declare dividend. Since it's a Section 8 company, they cannot declare dividend. So the decision of the company is not correct. Whether can declare. So, no, the company cannot declare. According to the provisions of the Indian Contract Act, define the following terms with reference to contracts of guarantee. Nature and extent of extent of surety's liability. Surety's liability is coextensive with the liability of the principal debtor. So he can be liable for the same amount or for a lesser amount, but he can never be liable for a more amount, more than what the principal debtor is liable. Then, second thing here, his liability arises the moment the principal debtor makes a default. And just because the principal debtor has not been sued does not mean the surety is discharged if there is no agreement to the contrary. Discharge of contract of surety by invalidation of the contract of guarantee. It happens in three cases: when the guarantee is obtained by misrepresentation, when the guarantee is obtained by concealment of material fact, or when one of the co-sureties refuses to join. So in all of these three cases, the surety is discharged. X was running a business of car on lease. One fine day, Y came to hire a car for 10 days for his business tour. X offered him a Honda City for 50,000. So it's a non-gratuitous bailment for 10 days on the condition that petrol and toll expenses will be borne by him. During the journey, engine of the car was choked. Y had to spend 10,000 for repairs of the engine. This is obviously extraordinary expenses, right? We know in a non-gratuitous bailment, ordinary expenses are borne by the bailee, and extraordinary expenses are borne by the bailer. For repair of engines, so here, this is one provision here, extraordinary expenses. When he was coming back from Amritsar, brakes of the car were not working and a major accident happened, due to which Y was admitted to the hospital and paid a bill of 50,000 on recovery. So this is damages which is, incurred due to faulty goods. Y asked X to compensate him charges for car repair and hospital expenses amounting to 60,000. X denied for compensation by saying that he was not aware. Okay. In case of non-gratuitous bailment, the bailer is liable for every fault, whether known or unknown to him. If because of this fault, the bailee suffers any damages, the bailee has a right to recover those damages from the bailer. Also, if in case of a non-gratuitous bailment, the bailee has incurred any extraordinary expenses, he can recover those extraordinary expenses from the bailer. So on this grounds, can we say he can recover 10,000 as well as 50,000? Yes. So give your opinion with reference whether Y can withheld the amount of higher charges of 50,000 on account of non-payment of damages. Now see here, the law very specifically has given that you have a right to claim the damages. But nowhere in law is written anything about withholding. Nowhere in law they have talked about anything relating to withholding the money, right? So, as per law is very silent on this. They talk about lien, but that happens for the goods, nothing about money. So we don't know whether he has a right. Let's see what the ICI suggests, but mostly, I guess the answer should be yes. But we will wait for the ICI because, as such, law has not spoken anything about withholding the money for the expenses and the damages. Whether X is liable to pay damages as he was not aware? Yes. In case of a non-gratuitous bailment, the bailer is liable for all the expenses, all the damages caused due to any faults, whether known or unknown to him. Delivery of an instrument is essential whether instrument is payable to bearer or order for effecting the negotiation. Discuss this statement with reference. Okay, so every negotiation must be completed by delivery. And you have to write about delivery. Delivery must be not only at the time of negotiation, but also at the time of making the instrument. And delivery can be actual and constructive. You should write about that because it's a 3 marks thing. You should write delivery may be actual or constructive. Differentiate between a promissory note and a bill of exchange. It's a 4 marks thing. So we can write 4 or 5 differences. Promissory note has 2 parties, whereas bill of exchange has 3 parties. The person who draws the promissory note is primarily liable to pay on that, whereas the person who draws the bill of exchange has a secondary liability to pay on that instrument. The when we talk about when we talk about promissory note, it needs no acceptance, but bill of exchange needs acceptance. Promissory note can never be made payable to bearer, but bill of exchange can be made payable to bearer, right? Explain in brief the important functions of Ministry of Finance and Ministry of Corporate Affairs and the Ministry of Law and Justice. So for 2 marks each of it, so you have to write about the Ministry of Finance, Ministry of Corporate Affairs, and Ministry of Law. P sold certain antique items to Q for 3 lakh on 13/12. As per the terms of the agreement, 75% of the amount was to be paid within a week and the balance 25% was to be paid till 31/12/24. Q appointed his agent R to take the delivery of the goods after the payment of the first installment. Q transferred a sum of 2,80,000 in the account of P through NEFT, which was credited in P's account on the same date. R failed to take the delivery of the antique item, so the goods are still with the seller. By the meantime, Q failed to make the payment of the second installment. On 10/1, Q's agent came to take the delivery of the goods, but P refused to deliver the goods and exercised his rights. According to the provisions, give your opinion whether P was justified in exercising his right of lien. When the seller has sold the goods but has the possession of the goods but and becomes unpaid, then in that case, can he exercise his rights of lien? Yes, he can exercise his rights of lien. So is he right in exercising a lien for 20,000? Yes. When we say unpaid seller, even if you are a partly paid seller, you are an unpaid seller. And if a seller is an unpaid seller, he has a right to exercise the rights of lien over the goods if he continues to have the possession of the goods. So yes, he can exercise. An auction takes place in Delhi for antique items. It is notified to the bidders that the sale will be completed only when the hammer of the auctioneer hits the table and he announces you are the highest bidder. So, see, sale is complete either on the fall of the hammer or in any other customary manner given. Here, they have said that the sale will be complete only when we say you are the highest bidder. So, that's the customary manner here which has been provided. During the auction, L bids for an antique sculpture worth 8 lakh. Hammer falls, but announcement cannot be made as the auction suddenly stops before the auctioneer can utter any words. It is notified to everyone that there has been an unexpected rise in the market price for that particular sculpture and therefore it will not be sold on that particular day. L contends that the auctioneer is bound to sell the sculpture to him at the price to bid he bid because once he bid at the highest price and the hammer fell, the auction sale was complete. Is it complete? No. Because here they have given it will complete only when we say it's complete. So they have given that customary manner. The auctioneer is under a contractual obligation to sell the sculpture. No. The auctioneer disagrees. Discuss the validity of the claim of L. Not valid. The partner indeed virtually embraces the character of both a principal and an agent. The implied authority of a partner to bind the firm by all the acts done by him and all the matters connected with the business is done in the usual way, not beyond the nature and scope of partnership. Explain. So basically, it's a Baba 7 marks ke liye what will we write? So basically, you have to talk about the mutual agency of the partners first of all, and yes, you have to talk about implied authority. You have to talk about everything about implied authority when it is not binding the firm. What are the acts which is not in the usual course of the business? Give your opinion with reference to the provisions of the Indian Contract Act where the joint promisor and promisee voluntarily discharge their obligation even after their death. Yes, if after the death of the promisor or the promisee, the legal heirs are liable and they can voluntarily go and discharge the debt. They can settle off the account for their respective shares. In case they won't be able to discharge their obligation, whether any one of the joint promisor may be compelled in case there is no agreement to the contrary and they voluntarily do not discharge. In that case, the promisee can compel any one of the joint promisors. So this is basically section 42 and 43, the provisions there. What would be the situation in case of default? Default, if one of them is not able to pay, he defaults in the payment, then his loss shall be borne by the others in their proportion. What are the effects of coercion? Coercion is threatening to commit a crime to force the other party to make a contract. The effect of coercion is the contract is voidable. So the aggrieved party may either cancel or affirm the contract. If he cancels the contract, the benefits received has to be returned back. Whether threat to commit suicide is considered as a coercion. Yes. Why? Because threatening to commit suicide is a crime and coercion is a crime. Ram purchased a second-hand car from his friend Rohan for 5 lakh on 10th November. He paid 4 lakh immediately and promised to pay 1 lakh within a year. But he could not pay the remaining amount till December 23. On 5th Jan, Ram received an invitation for Rohan's wedding which he could not attend but sent a check of 51,000 as a gift by post. When Rohan deposited the check, it was returned unpaid due to insufficient balance in the account of Ram. Rohan considered it as an offense under 138. Whether I'm so sorry, would be held liable for dishonor of check? No. Why? Because under section 138, you can claim for dishonor of check if it is in discharge of a legal debt. Here, the check was given as a gift, not in discharge of a legal debt. So, no. Whether Rohan was justified in considering this as an offense? No. Again, as we said, there is nothing for 7 marks here. Basically, you have to quote the entire section 138. Since it was, and whenever a check is returned dishonored, we have to give it back to the, give a notice to the drawer that your check has been dishonored. Here, because it was given for as a gift, it's not justified to think that it is an offense. With reference to the provisions, define the following terms: quasi contract and its salient feature. It's a contract created by law to prevent the unjust enrichment of one at the expense of other. What are the salient features? Those three. Created without a contract, then it is a right against the person and not the world at large, and it's a right to money and most often a liquidated sum of money. Responsibility of the finder of the goods. So, whenever a person finds goods belonging to another, there is a quasi contract between the owner and the finder, that the finder will trace the owner and return the goods back to him. What are the duties of the finder? He must take care of the goods, return the goods, not to use the goods for his personal use, not to make unauthorized use, praise the owner, and not to mix the goods with his own goods. Rights: he can recover the reward if announced. If he does not get the reward, he can sue. He can recover the expenses he has incurred. But if he does not get the expenses, he cannot file a case. He can exercise a lien for the expenses or the reward. He can sell the goods if the goods are perishable or the owner refuses to give the lawful charges and the lawful charges are two-thirds or more of the value of the goods. He has the rights of ownership over the goods against the whole world except the owner. Explain the following: pledge by a mercantile agent, both of this, and pledge by a person in possession under voidable contract. Both are valid. If a mercantile agent acting in the ordinary course of the business and has the possession of the goods or the document of title with the consent of the owner and pledges it to a bona fide person, the pledge is valid. Pledge by a person in possession under a voidable contract. When a person has the possession of the goods under a voidable contract and before the contract is cancelled, pledges it to a bona fide person, the pledge is valid. Explain with reference to Sale of Goods Act, reservation of rights to disposal. State the circumstances under which reservation of rights to disposal means when the seller puts a condition to safeguard the receipt of the money or not to dispose of the goods unless he has received the money. He has reserved the rights of disposal. How can he do it? He can do it in two ways. First, he can give an instruction to the carrier not to hand over the goods, even if the goods have reached the buyer. Or he can transfer the document of title with a bill of exchange, which makes it a conditional transfer that if you want to accept the if you want to accept the goods, you must accept the bill of exchange. Sometimes breach of condition will be treated as a breach of warranty, as a result of which buyer loses his rights to rescind the contract. State the circumstances, the four cases, where for his own benefits he treats a breach of condition as a breach of warranty, or it's a breach of condition, he should have claimed the whole price, but instead he claims only the damages. Third, contract is not separable and he wants to cancel only a part of it. And what was the fourth one? It is excused by law. So yes, overall, it was not, we cannot say it was a very tough paper, something which was doable. I hope your paper went well and all the best for your results. Thank you so much.